Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we'll hear today is Williams versus Fairfax County. And Ms. Vazegi, I guess it is, we'll hear from you first.
Good morning, Your Honors. Roya Vasegi for the appellant, Mr. Edward Williams. May it please the court. This case was dismissed on summary judgment for the sole reason that the trial court held that Mr. Williams did not put forth sufficient evidence to show causation to permit Mr. Williams' case to get to the jury. The causation, the decision of the trial court was based solely on temporal proximity. The trial court was required to take the facts in the light most favorable to my client, the non-moving party, but instead took the facts and evaluated facts in the light most favorable to the county, the moving party, and in fact, in the absolute most favorable light, just ignored all contradicting evidence set forth by my client. There was no small amount of evidence of temporal proximity between the protected activity when Mr. Williams made the complaint about Sonia Arenal, his de facto supervisor, expressing discontent with his openness about his sexuality and his marriage to a man. There was temporal proximity, evidence of temporal proximity between that complaint and the retaliatory actions that took place leading up to Mr. Williams' termination from the county. There was also evidence
Well, let's
of...
assume you have sufficient temporal proximity. It's a lot happened in between, and a lot up and down went in between, so you could question that some. But at some point, then, you still have to determine whether the county came forward with a legitimate, non-pretextual reason for firing or letting him go. He was a probation employee, right? Probationary?
Yes, he was in his probationary period. Yes, yes, Your Honor. That is correct. The county did put forth a reason that on its face seemed like a legitimate reason.
I mean, it was quite dramatic, wasn't it? They reviewed, what, 75 cases, and about half of them didn't have the risk resolved.
Not quite yet.
Highly public issue concern there that the whole agency, at the foundation of the whole agency is to take the risk of children out and have them placed and making sure that they're not in an environment that's harmful. And in 30-some cases, 35 cases or so, that was not resolved, and it alarmed the agency, and ultimately, who was it, Mr. Beckett's, terminated him.
Ultimately, he was terminated by Mr. Beckett's, Your Honor.
In April, yeah.
In April.
Yeah. Or was it May?
Beginning of May.
Early May, yeah.
Early
yeah,
May 2020. He was put on suspension, administrative leave on April 30th. There was a review of Mr. Williams' cases, and that was spurred by the April 10th referral, which was the second time the family was coming before the department. The first time it was handled by Mr. Williams' supervisor, and if I may just go back and correct, there was not a review of all of Mr. Williams' cases. There was a select review that stemmed from the April 10th referral, but if I could go back and...
I thought they came up with the notion that roughly 50% of the cases they reviewed were problems.
That is in the county's briefs, Your Honor. That is not what the report says. What the report says is from the select subset of Mr. Williams' cases that were reviewed due to documentation, it was unclear whether or not 50% of the cases were closed prematurely. Not that they were definitively closed prematurely, but that it was unclear based on the documentation. So I want to be very clear that child safety...
One other point of clarification.
Yes,
there was
Your Honor.
also, I thought they said 2/3 of the safety plans lack any reasonable safeguards. also. That 50% of the cases and then the 2/3 of them did not have any proper safeguards.
That I also believe is in the county's brief, and I don't believe that that is verbatim what the report says. There is a note about appropriate safeguards. There is a lot about documentation. I just wanted, if I could go back before I go back to the safeguards. I want to be very clear that the April 10th event, what happened with the children, nobody disputes, was traumatic for the two children that were in the car with their parents, with the mother. What I am saying, and there's no dispute that child safety is important, what I am saying and what the evidence below shows is that there was nothing that Mr. Edwards did that directly contributed, or didn't do, that directly contributed to what happened on April 10th.
Right, but there's evidence that there was inadequate supervision. His notes didn't say anything about the safety of the children, what the risk was. At least that was the evidence, was it not?
Your Honor, there, in the March notes from the initial, when the referral was Mr. Williams, because in April, the referral was no longer Mr. Williams. When it came in the second time, it was not his. It went directly to another supervisor. But in April, it belonged to one of his supervisees, by the first name of Letitia. And
You know, this is, I don't mean to cut you off, but,
No problem.
you know, this is really almost shocking in terms of this record. Usually, we have closer issues, and it seems to me that a lot of times it's difficult to discern whether the reasons given by the employer are pretextual. It seems to me you've got a really big problem here of showing that the county's reasons were pretextual in face of this record, particularly the fact that his notes were so incomplete that he apparently did not document any consideration for the safety of the children in the situation where the mother overdosed with the young children in the car. I mean, how can you say that the county, where is the evidence at all of pretextual reasons in this kind of shocking allegation?
So I want to clarify, and I think it's very difficult to clarify, there are two incidents. The one that was Mr. Edwards' responsibility, and he was supervising the program, the caseworker, was the March incident. There was no overdose in that incident. There was two parents and a mentally ill father, and the mother had given the mentally ill father the baby to hold, and that's why CPS was called. Mr. Williams' caseworker went out, evaluated the safety, decided that at that time, there was a safety plan put in place. The father was not to be alone with the children. The mother could be with the children. The mother was supposed to get drug tested because there was a history of substance abuse.
Right, but what did Williams's notes and his case notes show at that time?
His case notes, it was the caseworker's case notes for the March referral, not Mr. Williams' case notes.
Okay, but apparently there was only one supervisory note from Williams that made no reference to the safety of the children or ongoing considerations of risk or anything to manifest that as a supervisor, he had a level of concern for these children.
At the time, based on the March referral, or referral about the March incident, there was follow-up to be had based on to require the mother to get drug testing, but there was a safety plan in place, and there was follow-up and calls after the safety plan was put in place, and there was no safety issue at that time. There was follow-up, and then the caseworker went on vacation, and the April 10th referral came up and went to another program manager.
That's when they discovered the inadequacy of the record, and that did not prompt his termination. What that prompted was a review of his other work, and his other work then. I don't know what the proper adjective is, but from their point of view, it was not just a few cases. It was a total failure to carry out the agency's functions. And I don't know, you can dispute one by one, or they looked at them, but they did do a review of what he had been working on, and I think they were alarmed.
The county's documentation does show some level of concern. I am not minimizing, again, the April 10th incident or child safety. What my focus is that the appellant had put forth in the trial court evidence that this was not how all cases were evaluated, and this was not, what was being required of him was not necessarily what was being required for all other case,
No,
program managers.
The April 10th discovery of the inadequacy of the file and the notes and the risk, leaving open risk unresolved, prompted an investigation. And the investigation was of, I thought they investigated 75 cases, you say not. Whatever
Your
they
Honor.
did, didn't he have a caseload of about 75 cases?
He did have a caseload of 75
Anyway,
cases,
they
Your Honor.
reviewed enough of them that they were alarmed. And everybody then proceeded to action. And I didn't see a touch of evidence that it was based on the fact of his gayness or his gender or sex. I mean, as a matter of fact, Mr. Beckett's himself was in the same gender classification. So I'm just, the case was basically thrown out because there's no showing that this was pretextual. And whether we examine whether they overassessed it or whether they were clearly alarmed, weren't they? From their point of view?
The county represented that they were alarmed, but I want to be very clear that what I'm focused on is not that the reviews were done because of my client's sexual orientation, the appellant's sexual orientation, but because he made a complaint about a long-time, very well-respected member of a former supervisor and his coach at the time and de facto supervisor for making comments about his sexual orientation. There's no dispute in the record that she said, you should not be open about your relationship, and he went and complained about it to
But that
his
was
immediate
handled so
master.
completely. The person who reviewed it, understood it, supported him, was also gay. She never talked with, no, she was not. She was, that was Karen
DiMaggiano,
Yeah, anyway,
Majengo.
she was totally supportive. It seemed to me that that was, it's hard to complain about. I don't think he complained about how that was handled, did he? After didn't
Yes.
she address it very
Yes.
fully?
No, Your Honor, that is actually a basis for, one of the bases for the appeal, that the trial court didn't consider that the investigation, the HR investigation, was not handled thoroughly, that my client was only interviewed once verbally, not by the main investigator, and then Ms. Aronow, the well-respected, now former county employee, was interviewed not once, but 3 times, and submitted a written statement. And in that second interview, Ms. Aronow also flagged performance concerns for the first time on her way out in retaliation for Mr. Williams making the complaint against her. In the briefs, it is well documented and supported with cites to the record that this investigation wasn't done in good faith and wasn't done properly. We're not micromanaging or questioning how investigations should be done, but it is very one-sided, and then it was closed, and there are statements from Robin Harding, who did the investigation, saying, there's no need for me to talk to Mr. Williams again. It's very clear. Aronow made the comment. She's very sorry. She meant well. She meant it in a way that was supposed to support him by telling him that he should not be open about his marriage to a man. The interviewers, the HR individuals, were very sympathetic to Ms. Aronow and didn't interview anyone else other than Ms. Aronow 3 times and my client once. And that's part of the evidence at the trial court level for the fact that Mr. Williams was retaliated against for making the complaint, and his complaint was not taken seriously. Ms. Aronow was set to retire. The county didn't terminate Ms. Aronow. She was set to retire within 17 days of the complaint being made. If I may, because I am running short on time, and would like to reserve at least a few seconds for rebuttal. I just want to point out to your honors that Joint Appendix 998, Orianne Erickson, a division head in the Children, Youth, and Family Services Division, noted that there's no way with the volume that we have that somebody could be in every case, somebody in Mr. Williams' position, and that's not the program manager's role. So I just want to leave the court with that and reserve my remaining few seconds for rebuttal. Thank you.
All right, thank you. All right, we'll hear from Ms. Greensvike.
Good morning. May it please the court, my name is Jamie Greenswag, and I represent the appellee Fairfax County. And we would request that the district court's grant of summary judgment be affirmed because it was properly supported by the record. As it's been pointed out, there was a significant gap in temporal proximity between the time that the complaint was made and the time that Mr. Williams was separated from county employment. And as the court noted, there was an investigation following that January 16, 2020 complaint that was made by Mr. Williams. And he initially made the complaint to his direct supervisor, Ms. De Mahango, who, as you indicated, was completely supportive of him. She offered to support him in any way that he needed in making the complaint. She offered to support him with employee assistance program services, time off to do so. And she also told him that she would cancel the remaining coaching session that he had scheduled with Ms. Aronow. She did do that, and Mr. Williams was never again required to meet with, interact with, communicate in any way, shape, or form with Ms. Aronow. And it's not disputed that following that January 15th meeting, he never did, in fact, have any more communications with Ms. Aronow. When Mr. Williams went to the Human Resources Department for the agency, he met with Kamala Kawahara, who took down his statement of events. Ultimately, his version of events, as again you indicated, was adopted by the agency. They found that what he said was true, that the comments made by Ms. Aronow were in fact made, and that's in part.
But they did come back and say something about, oh, but she had good intentions. You wouldn't dispute that, right?
And I don't know exactly how it is that they phrased it, Your Honor. I believe it was something along the lines of she intended it to be guidance for boundaries, but regardless of her reason for doing it, they told him that comment, and they told her, more importantly, they told her, that comment was inappropriate and it's not in line with Fairfax County values. So for whatever reason you made that statement, you shouldn't have made it. And another point I'd like to make is that the county HR also told Ms. Aronow, don't have any, in addition to Ms. De Mahango, don't have any further communications with Mr. Williams. And so that point was reasserted by the Human Resources Manager for the Department of Family Services. So after this January 16th complaint, Mr. Williams is operating more independently. He no longer has a coach. Him and Ms. De Mahango had agreed that he no longer needs a coach, and so he's going about operating more independently as a CPS supervisor. I would just note that the last comment made by my colleague, that not all program managers can know all cases, Mr. Williams was not a program manager. He was a CPS supervisor, and so in terms of what's the importance of that, Ms. De Mahango was the program manager, and so she has 5 CPS supervisors under her, each of whom are responsible for 75 cases. And so 75 times 5, I should know that off the top of my head, I'm sure, but that's a lot of cases, and so Ms. Erickson was simply saying, Ms. De Mahango is not going to know everything about all of these cases. But the CPS supervisor is responsible for knowing everything about the cases of the subordinates over whom he has supervision. His primary job duty really is, on a weekly basis, Mr. Williams as a CPS supervisor was required to meet with his subordinates and to go over every one of their cases. And at any given time, that could amount to up to 75 cases. And that's the job. And so he's responsible for knowing what's going on in every case, and he has to document that, and what is his guidance for those cases moving forward. And that's in the electronic database. And the requirement for documentation, you know, the appellant frequently kind of makes flippant remarks to, oh, these are administrative duties. These are mandates by the Virginia Department of Social Services, not only what it is that the department is required to do to protect the safety of children, but also what it is that needs to be documented. So in terms of this review that takes place after the April 10th incident, what they're reviewing is objective data. What's the information that has been inputted by Williams' unit into the electronic database? And does that match up with what's required to be in that system by the Virginia Department of Social Services mandates? And they did find that in 50% of cases, it was either that a determination that the children were safe was unable to be made, or affirmatively that the case was closed before the children were safe, and in fact that they weren't safe when the case was closed.
Were there any open cases in this database?
Yes, Your Honor. There were both open and closed cases. And Ms. DeMahongo reviewed the open cases. Quality Programs is a separate department within the Department of Family Services that reviewed the closed cases dating back January, February, March, after Mr. Williams was operating more independently. And the findings between Ms. DeMahongo and the Quality Programs were consistent in that there were 2/3 of cases in which appropriate referrals weren't made. There were 50% of cases that were closed without a determination, without having been able to make a determination that the children were safe. And that really was the issue that came up on April 10th, was that there was this open case from March that Ms. DeMahongo saw when she looked at the case history after getting that call. And there's nothing in the case notes. And Mr. Williams wants to deflect accountability for the March 10th case and the April 10th the March 15th and the April 10th case. But the fact of the matter is, he's the supervisor over them. Had the March 15th case been better handled, we wouldn't have the April 10th referral. That was Ms. DeMahongo's point. You have an issue on March 15th where you have children who are in a house with parents who admit that they're drug abusers. The mother's handing an infant to the father who's having a mental health crisis, saying, oh, this will help calm him down, which is ludicrous, but that's what she's doing. The mother initially agrees that she'll submit to drug testing, but says, but I'll fail it. No plans put in place for drug treatment. Ultimately, the mother refuses to submit to drug testing, and nothing more is done. They just want to close the case. Well, now things have changed. The mother's not agreeing to drug treatment. She's not agreeing to drug testing. What are we doing? Are we doing a protective order? There's no notes. Who knows? Ms. DeMahongo has no idea what's going on in the case because the notes aren't in the case file. And Mr. Williams is responsible for those notes. And so when the April 10th referral comes in, she says to Mr. Williams, what's going on with this case? I need to know. I'm trying to put a protective order into place for this egregious event that just happened. And I don't know. Well, the CPS worker, she's out on vacation, so we really don't know what happened in that case. But he had recommended foreclosure. That's the only thing we know from the only note that he put in the file, was that he supported closing the file before there was any determination made that these kids were safe from their substance abusing parents. And that was tremendously concerning and alarming for Ms. DeMahongo. And so initially all she did was look through a handful of cases. Is this a prevalent pattern where he's not properly handling cases, or is this a one-off? And after she looks at a few cases, she becomes increasingly concerned because it doesn't look like it's a one-off. And so she goes to Ms. Erickson and she says, hey, look, we might have a problem here. I think that we should review this further. And that's when the decision to have an audit by Quality Programs and for Ms. DeMahongo to continue reviewing the open files is done. Those reports come back, again, consistently, that there's a number of failures on the part of Mr. Williams, including, again, failure to make appropriate referrals in 2/3 of cases, and failure to provide clear supervisory guidance in 3/4 of the cases. And that's his primary job, is to provide supervisory guidance to his subordinates, and he's not doing it. It's not simply an administrative task. And so when Erickson gets these reports from both Ms. DeMahongo and from Quality Programs, she reviews them, and she recommends that Mr. Williams be separated based on them. She sends those reports to the director of the agency, Michael Beckett, who is a gay man who's also married to a man. He reviews the reports, and he initially puts Mr. Williams on administrative leave, noting that the cases will be reviewed for possible discipline. And shortly thereafter, within about a week, he issues an unsatisfactory service separation memo terminating Mr. Williams from county employment. Mr. Williams was in his probationary period, such that he was not yet a merit employee. And these failures on his part, after having had significant assistance with a coach and having been on the job for numerous months, were unacceptable. It is the foundation of the agency to protect children, among other things. But making sure children is safe, it's one of the most vulnerable populations. This kind of poor supervision could not be allowed to continue. And Mr. Beckett's noted that in his unsatisfactory service separation that in the areas of child safety assessment, supervisory guidance, and safety and monitoring safety plans simply was not being done by Mr. Williams. And that's the reason that Mr. Williams was separated from county employment. I have 10 minutes left, but if you all have any questions, I'm happy to answer them.
Thank you very much.
Thank you.
All right, Ms. Vasaki?
I'd like to go back to the investigation because my colleague highlighted some things that are contradicted by the record. Going back to the investigation, the quality control investigation, there was an initial investigation by Ms. DiMaggio, the immediate supervisor that my colleague just referenced. Those documents were never produced, what cases caused alarm from Mr. Williams' case docket. And then the quality assurance referral or assessment was done. I've already noted some discrepancies in the language of the county's brief compared to the quality assurance assessment, and my colleague represented correctly this time for the court that this documentation wasn't sufficient. But there was a note and another mention of in two-thirds of the cases, the appropriate referrals weren't made. At the end of that report, Ms. Slappy's report, it says at the bottom very clearly that the appropriate referrals were not made in the domestic violence cases, but this is a failure of the county, and this has been a systemic problem in the county, and this is a good opportunity for the county to train its employees on how to do this better. Mr. Williams was in charge of all 75 cases, but at any given moment, he couldn't know all of the details for the 75 cases from memory. He had the notes in the system, and he had meetings with his caseworkers, the staff workers. The March 10th case that we're talking about that led to the alarm over the April 10th referral, I want to be very clear, the April 10th referral was with another supervisor, not Mr. Mr. Williams, apologies. That was a different case. There was some concerns about the notes. Ms. DiMaggio, when the referral came in on April 10th, it went to the other supervisor. Ms. DiMaggio came back on April 15th in an email and asked Mr. Williams to give a timeline of what happened, because this was a dire situation. The second time was a very alarming situation, and the county should be moving quickly. She asked Mr. Williams to put together a timeline of events looking at the notes. He directed her not to bother his caseworker who was on leave. That is part of why appellate's position is that this investigation and how he was handled wasn't done properly. We don't know how other probationary employees were treated. We tried to get that information in discovery and weren't able to get that information from the county. So there's no.
That's puzzling. You say you weren't able. Did you ever file a motion to compel?
We did not file a motion to
No,
compel. We flagged
there was
for
no
the.
pursuit on it. It's basically a complaint that what was served, discovery is an adversary process too, and both sides serve discovery on each other, and if you object to discovery, you don't think you got what you want, you ask for more, and if they refuse, you go to the court. That wasn't done, and so I don't see how you can say we didn't get everything we wanted and say that's something we should review.
I did try, Your Honor, and that is correct. A motion to compel was not filed. Depositions were, as in most cases, depositions were challenged to schedule. There was dispute over corporate rep depositions, scope of the topics. There was many meet and confers about the scope of what had been produced and what's left, but you are correct. There was no motion to compel filed. But the documentation and the way that Mr. Williams was asked to come up with the documentation for the protective order in that very dire situation that another supervisor was handling it just doesn't make sense. If it was a dire situation, why couldn't Mr. Williams reach out to the caseworker to fill in any details? He was put on the spot given some notes that maybe could have been fuller in the system for the March referral, but he wasn't given the opportunity to be able to actually diligently put together the information for Ms. DiMaggio to take to the other supervisor so that she could handle the referral. And as far as the record shows, The protective order wasn't even drafted until April 16th, 6 days after the referral came in. I just also want to point the court to the mandate from Ms. DiMaggio that, yes, that all cases should be evaluated thoroughly and children's safety as a priority, but there was also a mandate from her department, from DiMaggio, to close cases within 2 and 3 weeks. So there was a lot of criticism for the backlog of open cases and a mandate to close cases, but then also criticism of the notes not being sufficient and cases being closed. The quality assurance report that is the
I didn't
basis
quite
of the
follow
termination.
The logic of that, if they want you to close cases within a few weeks, they may say, basically want you to take the action that's mandated, which is to go out and find out what's going on and to make sure that steps are taken to protect the children. It's like a lawyer who has a caseload. You can let them sit or you can work them. And if there's a push to try to close cases, that's probably for the public safety, number one, and number two, to keep things moving. But I don't read that to mean that they're supposed to close the cases without resolving the risks.
Absolutely not, but there is a resource question as well, and one person being in 75 places at once. I also just wanted to end with.
Cases like everybody had, right?
Yes, Your Honor. If I may just close with the investigation that was the basis of the termination. I just want to note, again, it's in the briefs, that April 30th is when the administrative leave memo came out and said, we are going to be investigating your cases. The investigation had already been underway and completed by April 24th. So there's inconsistencies there as well between the county's reasons for termination and how they handled the termination and what actually happened, which also should be construed in the light most favorable to my client. And ultimately, the decision to terminate him had already been made on April 30th, and in fact, 2 drafts of the unsatisfactory service separation, effectively the termination memo, had already been circulated. So there are discrepancies in the record between what the county is saying now and what actually happened based on the evidence in the court below.
Is that it?
If I could just have.
Well, we do have a red light.
One moment. Oh, I apologize. Sorry. Yes, Your Honor, that is it.
Well, thank you. I mean, if you had something, I don't want to cut you off. You had something important to
I
add.
appreciate it. Thank you.
Okay. We'll come down and greet counsel and proceed on to the next case. ZF Transmissions, Gray Court, and I guess we'll hear from Mr. Bach first. Whenever you're ready.
May it please the court. Adam Bach here on behalf of East Coast Storage and Equipment. Your Honors, this case concerns a contract for the installation of racking at a manufacturing facility in Gray Court in Anderson, South Carolina for a company called ZF, who's the respondent here. The allegations of the case are fairly simple. East Coast provided racking designs and drawings for the installation of this racking system at ZF's facility and never got anything for it, was never paid for it, received no compensation for it. The parties offered different versions of what they agreed to. East Coast provided testimony and evidence that in exchange for providing the racking designs, that it would be the sole supplier on the racking system, and that its compensation for providing the designs would be provided through and attended to the project contract that would be executed through, as is common in construction, owner, general contractor, subcontractor, that East Coast compensation would come through that overall project contract. ZF tells a slightly different version of the story. ZF says that the oral agreement between the parties was that East Coast would simply be included, its designs would be included in the request for quotation that was issued to general contractors, and that East Coast would be included as one of the alternatives a contractor could choose as a racking sub-supplier.
So essentially, your case comes down to the fact that there was a disputed issue of material fact as to the consideration for this oral contract. There was no meeting of the minds.
That's correct. Well, that is correct, Your Honor. We would contend, as we are permitted to do under South Carolina law, bring alternative theories.
Right, I understand that. But as I understand it, your case encapsulated is the fact that there was no meeting of the minds. The facts were materially in dispute, so the issue of the oral contract could not be disposed of at summary judgment, and you were entitled to pursue the case on that, as well as the alternative theories of recovery regarding the equitable remedies.
That's correct, Your Honor.
Okay.
That's exactly right. And we believe.
Well, I think that's what I took from your briefs too, but I look at the contract as your client testified to it, and he was asked, but was there any specific sum of money offered by Christoph or anyone else that day to you? And his answer was, I was just guaranteed that I would be the sole supplier for the project. Okay, did you ever request a specific money from them in exchange for the drawings? No. I took their word that that would be the sole supplier, and the revenue would be derived from the project, the contract. Well, that's exactly what happened. You became the supplier, THS hires you as a subcontractor, and the expectation then would be you would get your compensation. So the contract as testified to, the oral contract as testified to by your client is what was addressed on the summary judgment, and the court concluded that that was fulfilled. And I could not find out any different. I looked at the specs, and they specified your client and that somebody could receive an alternative bid, but your client was selected as indicated, and then your client became the subcontractor. And that's the compensation. This was the compensation for the drawings. It says, and what happened during the closed-door meeting? I was guaranteed that I would be the sole supplier. And that was basically the quid pro quo. I'll do the documents and I'll be the supplier, and I'll get my money later under the contract.
Correct, Your Honor, which ZF then breached when it terminated.
No, but that's, ZF hired THS, right?
Correct, Your Honor.
And THS hired your client.
Correct, Your Honor.
And that relationship broke up, apparently, and that's been settled, right?
Correct. Well, Your Honor, what I would say first, the promise that ZF made, as we testified to, and which we believe a jury could find, infer from the facts and the light most favorable to East Coast, with all inferences drawn in our favor as the court's required to do at summary judgment, was that we were guaranteed to be the sole supplier, which ZF breached when ZF encouraged our termination. And in fact, that word encourage, Your Honor, is a little bit.
That's a breach, that may be an interference with the contract after it's entered into. But your contract, oral contract, beginning and ending, was to be the sole supplier. And that's what your man testified to. And he said it repeatedly in response to 2 or 3 questions. He became the sole supplier. In fact, he was the sole supplier.
For about 5 days, Your Honor.
Well,
before ZF then broke its promise to us.
That's another issue, but that's not breach of the oral contract. The oral contract was to make him a sole supplier, and he was, and THS, which was not a party to all of this, was person awarded the contract. And the more important thing is THS and your client have went to arbitration, and actually you didn't get there. You guys settled it. And so that issue is out. So if whatever they did wrong in terminating you was presumably taken care of in the settlement.
I would just also point out, Your Honor, I disagree with the court on that point. I think that ZF still, if I guarantee that somebody's going to be my sole supplier or sole distributor or sole painter or sole designer, and then 5 days
ZF
later,
didn't-
and
You just start with a proposition that ZF did not guarantee that they would be its sole supplier. GFC said it would specify that the contractor would specify the sole supplier, and the contractor did.
but it's our contention that ZF did promise that they'd be the sole supplier, and certainly at the
Okay.
summary judgment phase, we believe that we are entitled to a jury, if there's a disputed material fact on which a jury could find in our favor, we certainly think that we are entitled to. I would just like,
What's the fact?
And what
question?
is the, oh, I'm sorry.
Go ahead.
No, what is the disputed material fact?
that ZF promised us that we would be the sole supplier, which they then breached when they directed THS to terminate us. And I would just like to, before I don't know if we're moving on for this conversation or not, but I would just like to point out that ZF's position that it was just encouraging or suggesting termination is up to THS is not consistent with the record. ZF actually
But you
retained
know,
the.
breach of that contract, the subcontract between THS and East Coast, is a different issue than the contract for the drawings. The discussion for the drawings was the sole compensation was that they be made the subcontractor, in the specifications. And
That's the-
that was done. They were specified by name in the quote, and the contractor did in fact make them the subcontractor. Now, that ends that contract.
I just, Your Honor, I apologize, I disagree. I think that once ZF received our designs in exchange for making us the sole supplier, that they breached that when they terminated our contract, and I did want to just
So
mention.
you're agreeing there was a contract?
Well, it's our contention that there was, that ZF promised we'd be the sole supplier and that our compensation would come through the construction contract,
Okay.
through the construction project. But I would also
So if
contend,
there was, if you're agreeing there was a contract, then how are you entitled to plead alternatively equitable remedies?
Your Honor, it's a common pleading device in South Carolina. I would point the court's attention to J-Stip versus Richardson, Court of Appeals case from 2011 that we cited. In that case, the details of the contract aren't necessarily important, but in that case, it went to a jury trial where the jury found there was no breach of contract, that the parties had
But
acted
you
completely.
alleged a breach of contract,
We have.
and you're allowed to plead alternatively
Correct.
the equitable remedies.
Correct.
But if your breach of contract count is found to state a claim for breach of contract, then the others fall away, right?
No, I would say that, again, we're allowed to bring, so the
Well, you're allowed to allege them alternatively.
Correct.
But if you have a breach of contract came and it's found that there's a breach of contract, oral contract was made, and that's what the court found, right?
No, the court found there was no breach of the oral contract.
No, the court found there was an oral contract,
Oh, I'm sorry, correct. Your Honor.
right?
Correct.
And the terms of the oral contract are stated by Mr. Geddes here at page 103. And he says, was there any specific money? It was pressed 2 or 3 times. Was there any money promised? No. I was basically, in exchange for the drawings, I was guaranteed to be the subcontractor. And then he said, I will get my money through the subcontract.
Correct, Your Honor, and I think that.
But ZF didn't promise that. ZF promised to make them the sole supplier.
Well, this is where I think, again, by the court has jumped the gun here on summary judgment. Because, first of all, let me just say, in J-Stip versus Richardson, the South Carolina Court of Appeals clearly, in a case where no breach of contract was found, still proceeded to remedies on quantum merit. But we get to another problem with the court's order, which is that the version of the facts that was accepted by the court is not actually what's shown in the record. The version of the fact that's
I'm
accepted.
reading from the record here, and I'm reading your version of the contract right here. It's page 103, it's only about 10 lines long.
Correct. Your Honor, but what I'm saying is that accepting our version of the contract there was actually a real dispute about the contract terms at the lower level. ZF said something totally different about what they thought they agreed to than East Coast did.
I
A
thought they-
reasonable jury.
Let me ask you this, because I'm a little confused here, because I thought the argument below by ZF was that basically they only agreed to recommend you, East Coast as one of the potential subcontractors.
That's exactly right, Your Honor.
And I think even, I was looking at the lower court's order, and I thought that that's what lower court said, that there was, which I found was interesting at J 413, that the court acknowledges there was a conflict between the terms of the agreement.
Correct, Your Honor. And
Okay. So the argument that you were the sole, and I'll ask them this, is if, because I thought the dispute was that they are saying that you all were supposed to be given the opportunity to bid, and they would be recommended in exchange for you doing the drawings.
That is absolutely correct. That is all that ZF ever testified to.
And the court resolved that dispute. This is what the court said. Assuming that East Coast created an issue of fact with respect to whether it was guaranteed the racking subcontract, the undisputed evidence established that East Coast in fact was awarded the racking subcontract. Court then found that dispute immaterial.
But, Your Honor, I think that finding is irrelevant to a question of whether or not we get to proceed with equitable theories, because
No,
a
if you have a
jury,
contract,
because a jury could find that there was no meeting of the minds. A
but you're
jury could-
alleging it. You can't come and say there was no contract. If you're alleging there's a contract and the court accepts it, whether it's a jury or a court, you can't come back and say, I didn't allege a contract.
Your Honor, that is, respectfully, that is not the way that pleading works in South Carolina, nor has it ever.
It works
That-
the same way in South Carolina as everywhere. In other words, you plead alternatively. You're
Correct.
entitled to, the federal rules provide for that. But you can plead alternatively if the jury finds there was no contract. But the court here accepted your contract.
Jesdip versus Richardson, I just again point to the court, the jury actually found there was a contract, there was no breach of the contract, and the court still proceeded to consider the equitable remedies under quantum meruit. Because, Your Honor, the elements of quantum meruit are, did you get a benefit from my client? Was that provided non-gratuitously? And did you retain it under circumstances where it's not fair that you did so? And that analysis can happen whether there was a contract, wasn't a contract, a breach of contract. In Boykin, they found no contract, that there was no meeting of the minds, and same with Braswell versus Heart of Spartanburg Hotel. No meeting of the minds, so you get quantum meruit. Jasdip, they found there was a meeting of the minds. You still can proceed.
You've lost the argument. It seems to me, though, that your position here today, you're conceding that there was a contract.
Your Honor, our position is.
And you're saying it doesn't matter that I'm agreeing there's a contract, because under South Carolina law, I can still, because this contract was breached and I didn't get anything from ZF, I can still proceed under quantum meruit, notwithstanding the fact that I have alleged and proved an oral contract.
Correct, Your Honor. I think it's so important to consider where we are in the phase of this case. We are at summary judgment. I believe that we have the right to go forward with the jury with all of our causes of action. If the jury concludes that we had a contract that covers these same services and it was breached, then certainly we would be required under South Carolina law to elect our remedy at that point. Do we proceed with our contractual remedies, or do we proceed with our quantum meruit remedies? But they are not exclusive.
Okay, tell me how that would happen under South Carolina. So the jury you're saying would be given a question as to whether there was a contract between the parties?
The procedural history in Richardson is instructive on this, Your Honor. Again, the case was tried, the jury found no breach of contract, the jury was dismissed, and then but the jury did find as to quantum meruit, I'm sorry, the jury didn't find as to quantum meruit, the court did find as to quantum meruit, and the court said, we'll proceed as to the equitable portion of the case. And I see that.
I mean, I would think, I'm guessing that in South Carolina, and I probably shouldn't guess, but that the equitable remedy is a matter for the court.
Correct, Your Honor.
And so,
So
there would have to be a two-stage proceeding.
and traditionally, the way that it's
If there's going
done.
to be an equitable remedy.
Yes, Your Honor, and traditionally, the way that it's done is or the way that I've seen it done is that the entire case is tried before the court. The jury decides on the legal questions, and then the equitable questions are for the court based on the same record and evidence. It's not a very burdensome procedures. Thank you.
Okay. Thank you, Mr. Bach. You have some rebuttal. Mr. McNally?
Just before we get started, you don't dispute it as the way that it's handled in South Carolina? The equitable, the jury trial and then the equitable portion of it?
Well, I do dispute that because both below and here, they concede that an express contract exists. The equitable claims fall away if that is the case under South Carolina law.
In what case are you citing to
Well,
support
if you
that?
look at, I mean, I think there's a couple of different cases that we've cited in our briefing. I mean, number one would be Williams Carpet Contractors versus Skelly, which unjust enrichment is not available when a plaintiff seeks for the specific task that's covered by the express contract. As it relates to promissory estoppel, it's the same result in Volvo Construction Equipment versus CLM Equipment, which was a 2004 case from this court, also concludes the same thing. The promissory estoppel cannot coexist once the express contract exists.
Once I guess there's a determination by the jury that there is that there is a contract, right?
Well, in this record, both below and today, as Mr. Bach acknowledged, they admit that there's a contractor. And Judge Niemeyer pointed out the very crisp testimony from Mr. Geddes that acknowledged that this contract existed.
Okay, but once, help me with the procedure, because I'm not well-versed in South Carolina law. Once, you're saying the jury makes the determination, if the parties ask, whether there is a contract, is that correct?
That would be correct. If there was an
Okay.
allegation, there was no meeting of the minds, and that there was not the existence of an express contract, the jury would make that determination first.
And you're saying that in this case, the jury would not make that determination because they were alleging the existence of an oral contract?
Well, in this instance, it was appropriate for the district court to grant summary judgment under Rule 56 because of the existence of that express contract. That is the point. If both parties hadn't conceded that that contract existed and this went to the jury would make the determination first on the express contract, and if an express contract did not exist, it could go forward and consider whether there was implied contract theories that East Coast carried its burden.
And you're saying that the jury would determine the equitable remedy and not the court sitting in a chancery capacity?
The court would consider the remedy if the jury made the finding on the implied contract theory. So I agree on that. And really the nuance between the unjust enrichment and quantum merit is just the approach on what that remedy would look like, whether it's the value of the benefit conferred versus the value of the services provided. Just a slight nuance between those two theories.
Just to reiterate on the contract issue, I had thought, based on the record and what the testimony was and what the court found, is that both sides agreed there was an oral contract. There was a disagreement as to whether East Coast would be recommended or whether they would be guaranteed. They said they'd be guaranteed, you guys said it'd be recommended. That's a dispute. The court said that dispute doesn't matter because they did become the subcontractor. And as a consequence, but nobody disputes there was a contract. It was just whether they would become the subcontractor. And the court said, in fact, they did become the subcontractor, and therefore that was fulfilled. It doesn't matter which version of the contract. They both agreed there was an oral agreement made there, and there were some notes of that meeting made. And I can't remember what the notes exactly said about that, but
So the notes from the March 27th meeting indicated there would be no guarantee, that they would be included as a preferred contractor in the RFP process, but you're exactly right.
But the court concluded that there was a contract, but the dispute over whether it's recommended or guaranteed is immaterial, doesn't make a damn bit of difference, because East Coast did become the subcontractor.
I liked your lead into the fact that it did make a difference, because that was exactly right.
Well,
And as-
I just want to be clear, because I'm confused about what position you all are taking. Are you saying that the agreement between ZF and East Coast, based on the oral agreement, your position is that they were supposed to be, he's saying sole supplier, my understanding was that your position was we are only recommending them, we will only recommend you to these contractors as a subcontractor.
It was a requirement that the responsive bidders needed to include East Coast as a subcontractor for the rack system in their proposals. That is what ZF advanced in the lower court based upon the record evidence. Mr. Geddes testified that in the closed-door meeting that occurred at the end of the March 2017 kickoff meeting, that they would be guaranteed to be the sole source. What Judge Kane analyzed
And
and
you're
considered.
saying that we never guaranteed that, right?
We do say that. The meeting minutes say that. Our testimony says that.
That you never guaranteed.
We did not guarantee.
Okay,
It
and
was-
so let me ask you this. So how are you, how do you deal with Mr. Everton's testimony? Mr. Everton that is, I guess he's the president of THS, who says that it was his understanding also that it was I think it's JA, let me put my glasses back on, JA 206 through 207, 323, 330, 37, 39. He says that he was under the impression that they were required also to use East Coast in their proposal.
That's exactly right. We observed at the lower court that that testimony was not taken in this case. It was taken in the separate arbitration. It was only presented 4 days before the dispositive motion cut off. However, we don't disagree with that fact. They were required to include East Coast in their bid to adhere to the requirements of the RFP process. Judge Kane then took a
But
look
now,
at
I
that.
think the testimony is that they were required to use them, to hire them. And then he goes on and he talks about the termination and that they were instructed to terminate the contract with, that basically that ZF is instructing them all along the way as to how to handle this contract with, how to handle the bidding process, how to handle the contract, all along the way. So my question to you is how do you, that line of testimony from Mr. Everton line up with your notion that we just basically said that we will recommend, you're not required to? When it sounds like if you read what Everton says, that they were required to, which would be consistent with what he's arguing.
So I would say three things, Your Honor. First and most importantly, we believe that testimony was not properly before the lower court. Regardless, it was not a material issue in dispute, as recognized by Judge Kane. They
Well,
were-
yeah, but it seems to me that maybe we have perhaps an inartful argument here, because if there is a dispute as to a consideration, they're saying we had a contract and the contract provided X. You're saying we had a contract and the contract provided Y, okay? Why isn't that a disputed material fact as to the meeting of the minds, not to be resolved at summary judgment? That's what I'm having trouble here.
Because they received the subcontract from THS. So there's two important things here.
Right, but why wouldn't a jury be entitled to infer that if you received the contract, you were entitled to perform it? You weren't simply chopped off at the knees after 5 days.
Not at all, Your Honor. And I think there's two important points. ZF's performance was fully complete at the time that that contract was awarded. East Coast then elected to enter into a contract with THS, that subcontract, and that had two critical provisions in it. Number one, it's Section 4 of that agreement was the only provision providing for compensation to East Coast regarding this project. All of the testimony was, both from Mr. Giddis and from Mr. Zeff at ZF, that there was never a promise of compensation by ZF to East Coast. It was that contract between THS and East Coast.
Okay, so what you're saying, and I don't mean to cut you off, I want to make sure I understand. So what you're saying is that ZF only promised, I will get your foot in the door. After that, you're on your own with THS.
Exactly right. Under the contract that they negotiated, and as we
Well,
observed,
that's inconsistent with Mr. Everton's testimony. And I understand you're saying you dispute because that was in a separate proceeding, but it's sworn testimony, right? I mean, he said that you all required them to hire them as a subcontractor. And then he also testified that you all told them to terminate the contract and also told them not to pay it.
So
They
let me,
can't pay any compensation.
let me comment on those facts, because there's a critical contradiction in East Coast briefing against the record. So that contract contained at a section 11C between THS and East Coast, which they did not include ZF as a party in, a termination for convenience provision. There was one email after THS informed ZF that they were having performance issues with East Coast 5 days into the contract, that there was going to be, that they would encourage that they move on from the contract. ZF then subsequently notified that it was THS's responsibility to make the determination for what it was going to do. And in addition, there was a subsequent letter from Mr. Schenk at ZF informing both parties that they should perform their respective contract obligations. At the time that the termination occurred, and prior to that, there was a change order request submitted by THS to ZF regarding East Coast. And what that provided, and this is the big distinction and contradiction in the record, is that they were seeking additional compensation because East Coast had not performed, had not completed the design drawings, and they wanted an increase in the contract price as a result of it. So in this record, East Coast originally does some drawing work on the rack system within this automated retrieval storage system. They spent $8,600, $8,640. They don't even complete the design work. And as that termination scenario progresses, it is East Coast that tries to get additional money for the fact that they haven't performed. And ultimately, THS is the party that made the decision to terminate under the convenience provision, which allowed them to terminate for any reason or no reason at all, and invited in that termination notice East Coast to submit any of the invoices for cost incurred through the project at that point, which is what became the subject matter of their dispute that went to arbitration and was ultimately resolved.
I guess, and even the lower court, and I guess this is in follow-up to what Judge Keenan said earlier, it seems as if I'm not sure anyone's disputing that there was some oral agreement, but it just seems as if there's some conflict regarding the terms of the oral agreement as to a meeting of the minds as to what was agreed to. And I mean, I can't help but even look at which is JA 413 or page 12 of the district court, where he says they dispute terms of that agreement, offering conflicting evidence as to what precisely the ZF defendants were obligated to give East Coast in exchange for the drawings for the racking expansion at the plant. I mean, so even the district court is acknowledging, I'm not saying that there was what the agreement was or whether y'all breached it or not, but we're at a 12B6 stage, and the district court is saying that there's conflicting evidence.
Well, I think what Judge Kane observed on, and I think that's on 413, is that it wasn't a material dispute of fact because they ultimately were awarded the contract. That is really the crux of it.
The only dispute that the parties talk about is recommend versus guarantee.
Exactly.
But they all agree there was a contract. The notes tend to favor you, the notes taken at the meeting.
That's exactly right.
But regardless, if you give East Coast its version, which is that they would be guaranteed, they in fact did receive it. That's your position, and it's immaterial therefore. That's what the district court concluded, that they received the contract, and therefore the dispute, that term of the dispute. It's a little bit like a contract says, I agreed to pay 12 cents for a glass of lemonade, and you say, no, it was 11 cents. Well, if they paid 12 cents anyway, that dispute doesn't make anything. They sold the lemonade and they paid the 12 cents, so somebody can't come and say we had a dispute of fact as to whether it was 11 or 12.
But if you never got the lemonade, it doesn't matter?
Yeah, if you never got it, it does matter.
Well, if you never got the lemonade, it does matter, but here they got the subcontract.
They got the subcontract.
And they elected not to include ZF in that. They elected not to include a compensation term between ZF and East Coast, and then it was their job to perform. And recall, they are the party that entered into the contract with a termination for convenience provision. So as they've talked about this encouragement, and Judge Kane appropriately noted this on page 13 of his opinion, if they had some complaint after our contract was performed, that would have resonated in tort, specifically tortious interference is what Judge Kane observed. I'm happy to answer any other questions that the court has this morning. I think clearly if the express contract exists, the implied contract theories as said today fall away, and I think any dispute of fact here is not material in looking at the evidence most favorable to the non-moving party, and it was appropriate for the district court to grant summary judgment. We'd ask that that be affirmed.
All right, thank you, Mr.
Thank you very much.
Mr. Bach?
Thank you. I'd just like to mention a few things. First, I think Judge Keenan's statement is exactly right, that it is a reasonable inference that a jury could draw that when somebody is guaranteed that they will be the sole supplier of a racking system or lemonade, that the person cannot terminate the very next day, and that a reasonable inference is that we will be entitled to complete the contract. That is what it means.
Was ZF, you know what I'm worried about, your theory, Mr. Bach, and my articulation of your theory is, was ZF in a position to deliver guaranteed performance? Or were they only in a position, based on THS's status as the general contractor, were they only in a position to deliver access as opposed to full performance? And your argument is full performance, but were they in a position to deliver that?
Your Honor,
By
excellent.
contract, by their contract?
Excellent question, Your Honor. I will say that I believe it's at 302, paragraph 12 of the ZFTHS contract. They do exercise some control over which subcontractors they allow in
Okay.
their facility.
Could you give me that site again?
I'm sorry, it's Joint Appendix 302, paragraph 12 of the ZFTHS contract.
Okay.
They do exercise some control over who can and cannot be a subcontractor at their facility. I'd also just point the court's attention back to the string of testimony between from Emberton about the termination. In fact, we showed him an email where Mr. Zeff from ZF tries to push responsibility for East Coast's involvement in the project back on THS. And I asked him, I said, there's an email from Christoph Zeff in August 2017 where he says it was THS's job to pick the subcontractor and your job to manage them. Any idea why Mr. Zeff would say you all picked EC or that it was your responsibility? Answer, no, I don't. Mr. Emberton from THS, no, I don't. Question, that was not y'all's understanding. That's correct. That was not our understanding. He goes on to say, I asked him, Mr. Emberton, so in order to use somebody other than East Coast, it was your understanding that THS would have to get approval from ZF to do that. Answer, correct. A jury could certainly infer based on Mr. Emberton's testimony. I don't think they have to infer. It is what Mr. Emberton testified to. This is, and I do think it's important to take a step back and recognize that this is an incredibly common arrangement. This is not some contract that we've never seen. It is an owner trying to get work through a general contractor with a subcontractor. And I don't think any jury would have a hard time understanding that if I own a house or a manufacturing facility, I can decide who comes in there and who doesn't. And that if I require that we use my painter or my roofer or my designer, certainly the general contractor could say, I don't want to take the contract under those conditions, but the owner has the right to, and if they take it, as Mr. Emberton says, we did. We agreed we'd use East Coast because you all required it. They did have the power to see that their promise that we remain the sole supplier, which they breached when they brought engineered products on as a second supplier, is accurate. I would also just, to the court's questions about the procedure below, I meant to bring the Richardson case up here, but I grabbed the wrong one. Anyways, I'm sorry. Again, in the Richardson case, the court, it's a real estate contract. Earnest money was paid that was supposed to go towards the purchase price. There was a written agreement. The contract was not performed for whatever reason. And again, the jury found neither party breached the real estate contract. But the owner tried to retain the earnest money. And the lawyer following the jury's verdict requested a ruling from the court on its quantum merit action. It proceeded to quantum merit, found that the earnest money that had been paid in was a benefit that was conferred upon the owner, that it was inequitable for them to retain, and therefore the quantum merit action could proceed.
So is your position that if you were allowed to, if this case was allowed to go to trial, you would try to breach a contract case if the jury says that there's no breach of contract?
Correct.
Then the district court would be, at that point, would decide on the quantum merit and unjust enrichment claims?
Correct, Your
If the jury says there is a breach of contract, then you would continue to pursue the breach of contract. You would move forward, I guess, on the damages on the breach of contract claim And at that point, the court would not consider the other.
Correct, Your Honor, and you know more about this than I do. I know you were on the bench there, but I also think that the court could require the parties to elect their remedies at that stage too. They could say you were found for on breach of contract. You can now at this point either proceed to damages under the breach of contract, or we can go forward on the quantum error claim. And Your Honors, I see I'm out of time.
Okay, thank you.
Thank you.
All right, we'll come down in Greek Council and proceed on to the next case. The statute does say DSS has to receive it, but it doesn't say necessarily directly, as long as DSS is in the target line of reporting. I mean, I cannot believe that a student reporting child abuse or a daughter reporting child abuse of a stepfather to the mother, and then the mother reports it to DSS. The child, there's no immunity? That just frustrates the entire statute, because almost all child abuse is being observed by someone, and for them to know, they have to go to the nearest DSS office as opposed to somebody who's going to take them to that office, would be a total frustration of that statute.
Well, Your Honor, I'm not sure it would be a total frustration. So we're not talking about strict liability here. We're talking about whether they have immunity or not. And that's an important distinction to make, okay? So,
Well, I'm not talking about strict liability either. I'm talking about, if I said it, that's wrong. I'm talking about immunity. The legislature clearly wanted to encourage this type of reporting to protect our young and to protect against child sexual abuse.
well, the legislature did want to encourage
And
that,
they
and
go
they
out
baked
of
in
their
the
way.
language.
They have mandatory reporting. Anybody they can think of that would be in a position to mandate, they've mandated. They mandated teacher reporting. They mandated law enforcement reporting. They have a whole list in 1509. And in 1509, they give them immunity too. There's a separate immunity clause.
1509 are
Yeah,
mandatory
yeah.
reporters, Your Honor. 1510 is what we're dealing with under this
I
statute
know,
for
this is,
Delta.
people do not have mandatory reporting, but both of them say the same thing, that when they witness, a person who witnesses child abuse and reports it to DSS is immune. And your argument is, it's fair enough, the statute seems to suggest that the reporter has to go directly to DSS instead of indirectly.
That is the express
And-
wording of the
yeah,
statute, Your
and-
Honor.
Well, I'm not sure that direct or indirect
To what extent are you relying on the fact that there are other places in the statutory framework that refer to law enforcement, and the legislature did not choose the words law enforcement in this place? Do you
Yes,
find-
Your Honor. Numerous places, but 1507, for instance, where it says DSS may collaborate with law enforcement. And that in itself says, Your Honor, that the legislature knew that law enforcement existed, that they chose not to put it in 1510, which is the statutory immunity provision that Delta is relying on in
Well,
this
they
case.
put it in 1509 too. And the legislature wants DSS to get the information because they have the tools, they've empowered the agency, they have the expertise. So.
Well, that's an interesting question,
No,
Your Honor,
just
and I think
let me
that's,
just
yes,
get
sir.
to my point. They want the information to get there, and to encourage it, they make the people they can control require them to report it to DSS, and those who they can't control, like the public, they give them immunity if they report it. My only question is the fact that the report has to get to DSS, or the statute says report to DSS, does that mean it has to go directly, or can it go through a parent or a teacher to DSS? And if it can go to a parent or teacher, then it doesn't mean directly, it means indirectly is okay.
Well, I think it deals with what a report or a complaint is, Your Honor. So,
We're talking about child abuse, we're talking about sexual abuse, observation of conduct that fits the statute.
well, under 63.2-1503, for instance, Your Honor, it says the local department, meaning the DSS, shall be the public agency responsible for receiving and responding to complaints and reports.
No dispute about that.
Well,
The
there would be no
legislature clearly
actionable-
wants DSS. The real question is, does immunity depend on a direct call to DSS, or can it be an indirect call? And the statute is silent on that. And my suggestion to you is that it would totally frustrate the statute if we were to say only those who made a direct call to DSS get the immunity, whereas the person who makes an indirect call doesn't, and yet accomplishes the same purpose.
I have to respectfully question that, Your Honor, because let me answer that with a question. If any of you witnessed a murder, a robbery, or a carjacking this morning, would you call the police? And the answer is clearly yes, so would I. But do you have immunity for that? No, you
Okay,
don't.
Let me ask you, is there any evidence that law enforcement pursued this case and made a report to DSS?
No, Your Honor.
Okay, so there wasn't an indirect reporting scheme here
No, Your
from
Honor.
one to the other?
Well, the
What-
law enforcement was mandated to do it, and they'd be punished if they didn't. What they did is
Well-
she reports it to the captain, right?
Yes, Your Honor.
Now, if the captain said there's nothing to it, that ends the matter. It doesn't get reported to DSS. This went down a chain that would have gotten to DSS because we presume law enforcement is going to follow its duty. It's mandated, and they're going to be punished if they don't. And they're taught about this, and they've cooperated, and 1507 talks about how they have to cooperate in their reporting, both for law enforcement, DSS to law enforcement, and law enforcement to DSS. But the question is, in this case, that they didn't have, there was no information. So we could presume, though, if there was a serious conduct that was covered, it would end up in DSS. That's a secondary question. My first question is, if a person voluntarily reports it to a teacher or a parent, which is probably the two most common that we get of observations, and the parent and the teacher then report it to DSS, you say the person reporting does not get immunity.
Well,
And
you're
I
right.
would say that frustrates Virginia legislature right to the ground.
Well, the issue is, Your Honor.
Well, let me ask you real quick, because I think the scenario that Judge Niemeyer is giving you is similar to the Goldberg case, just a different statute. And I know you cited it earlier, but I don't think that case helps you because in that case, they were making the same argument. And that's the case where the issue is where the statute says that DSS can turn over information if it's unfounded. And I think the case there, they said, well, the grandmother reported it to someone else and they reported it to DSS. And in that case, in Goldberg, and this is the Virginia Court of Appeals, obviously, said that somewhat similar to, I guess, what Judge Niemeyer, you look at the structure of the statute and determine the intent. And they said that, that basically, in this same example, that yes, it would be, you would have the immunity there.
Okay, that was a little bit different immunity
Yeah,
statute.
yeah, no, the statute was, I know
Your
the
Honor.
statute's different.
So,
yeah.
so the issue there was whether they would still have a remedy to discover the materials. And so I don't think that case is on all fours with this one. The real question here is the first question is, does Delta have immunity? And under the express wording, they don't. The fact that law enforcement was used elsewhere, but not in 1510, they don't. The fact that it's a statute and abrogation of the common law.
I just want to get the principle, because then we can go on to the next step. But the question is, your argument is that the reporter of the conduct has to report directly to DSS, or they don't get immunity.
Correct, Your Honor.
And I'm suggesting to you, if they reported it to their parent or grandparent or the teacher, and it then got to DSS, you're saying they would not have immunity.
Well, I don't know that a statement relaying the information is the same thing as a report under the statutory scheme, Your Honor.
No, the
report
reporter
or
is the
complaint-
person who observes the conduct. So a teenager observes the conduct, or a very serious conduct.
Yes, sir.
And the student reports it to the teacher, and the teacher reports to DSS, and DSS addresses the conduct.
Okay.
No immunity under your reading.
There's no immunity, there also would never be liability under that
Sure.
scenario, Your Honor. But the fundamental difference here is the difference in the way that DSS approaches the report. So for instance, under 63.21503A, that they have the responsibility to respond to complaints and reports, DSS, not the police. So under subsection I of that statute, DSS has to determine the validity of the report of child abuse or neglect. So that's before it even goes to the police.
My hypothetical does not involve the police. That's a different issue. Because the question is, if it can be an indirect report, then the question is, when the teacher reports it to the police instead of DSS, and then the police report it to DSS, is that any different? And then the question is, if the teacher reports to the police, and the police say there's nothing to it and I'm not going to report it on, is the student still protected? And my suggestion is, in all of those, the legislature intended to protect the reporter in order to encourage uncovering misconduct of the kind as so at the core of protection of the youth.
Your Honor, I'm not sure that those are, the whispering of what happened versus an actual report to a state agency is what's at issue here. So what was reported was to the police And Mr. Cup got swatted coming off the plane and separated
I know,
from
you
his
keep-
family. It's
you
very
keep-
different.
You keep jumping off my issue. You're unwilling to, my issue is the statute says a person reporting to DSS is immune, right?
Correct.
My only question to you is, does that mean there has to be it gives immunity only to persons who report directly to DSS? Or will it give immunity to a person who reports to a grandmother and then DSS?
I think any report that's not made pursuant to the wording of the statute, Your
What's
Honor,
the
is
answer to
not
my
immune.
question?
It's not immune.
All right, that's what I
And-
thought.
Do you
and
have any problem with certifying this case to the Virginia Supreme Court?
I do not have
I
any
mean, they're a
problem.
notorious plain meaning court. I mean,
Yeah.
I can tell you that.
I,
I spent half
I
my
think
life
based on the
on that.
district
So,
judges,
But, you know, there's a very good argument that the legislative purpose was to protect children. I mean, I think that goes without saying. So why not put it to the Virginia Supreme Court? You're a plain meaning court, clearly, your history is plain meaning, but we have a statute that apparently contemplates this situation to protect children. What gives does the plain meaning govern? What's wrong with doing that and getting the word from the highest court of the state?
I see no harm in doing that, Your Honor.
Uh-huh.
None whatsoever. And considering the district court's the judge's hesitation to make this pronouncement in this case, I think it makes sense.
All right, we'll hear from you again.
Thank you.
Let's hear from Ms. Grace.
Is it still morning, Your Honor? Good morning, I think.
Yeah.
May it please the court. My name is Catherine Grace. I'm with Wilson Elster, and I'm here on behalf of the Appellees. And I'm going to lead by saying the cliche, protect the children. There is zero
Well,
doubt.
That's easy. The statute, Mr. Ford pointed out correctly, the statute says the person making the report to DSS is immune. And my question is, do we read the word directly or indirectly into that? The example I've used with my law clerks is that the Sherman Act says any contract combination or conspiracy in restraint of trade is illegal. And, of course, every single contract that's entered into restrains trade because it precludes somebody else from doing the contract. So the Supreme Court reads into the word any restraint, any unreasonable. They added the word unreasonable and, of course, developed the body of law. The question I have here is, this is intended to protect children. The legislature clearly was after it. And they did say they want the reports to DSS for a lot of good reasons. DSS has got the machinery, they've given them the expertise and all this other business. But the question is the immunity dependent on a direct report or a direct or indirect report? And that would be the first question. The second question would be, if it's made indirectly, like say to the police who have a mandatory reporting aspect, but the police make a decision that there's not enough there, would that still be a protection? Because the police, if it was a legitimate claim, the police would presume to follow the law and to report it to DSS. In this case, that was what happened, but that is a second issue of whether the chain is not completed because of that, the lack of evidence. But I think the more important question, and I think what Mr. Ford's raising, is the statute says immunity is granted to the person reporting to DSS. And the child that reports to the teacher who reports to DSS does not get immunity then, and the student. And that's a very common context in schools where we see it, and we see it in homes where often with a stepfather who's abusing a child, somebody witnesses and complains to the mother or to school. Oftentimes it goes to school. But all of those would not have immunity if that's the reading. So I don't know how you can help on the statute. The statute has a lot of indications that law enforcement and DSS is supposed to work closely together. That may not solve the problem, though, of Section 1510, which has the immunity provision. There's a same immunity provision in 1509, I think, for the mandatory reporters, but,
Ms. Grace, aren't you asking us to add language to the statute? Virginia is so hostile to legislative purpose in terms of statutory interpretation. And it just seems to me this is a classic case for the Virginia Supreme Court, the highest court of the state, to tell us. Because I agree with you that I think the legislature probably intended this, but what the Virginia Supreme Court characteristically would say is they may have intended it, they didn't say it. They're free to amend the statute at the next available opportunity. We encourage them to do so. Do you have any objection to a certification in this case to put it to the highest court of the state? What's the deal? Does the statute cover this or doesn't it?
Judge Keene and Judge Niemeyer, forgive me, I'm going to try to answer all of the questions. Let me start with, I don't believe there's a need, because I believe there's a clear answer to Judge Niemeyer's questions. Number one, it does not say directly to DSS. We all agree that the intent of the statutory scheme is to protect the children. And if you follow the statutory scheme, you absolutely get to law enforcement. In fact, DSS is supposed to be working with law enforcement also. But I think the easiest answer to your question is, even if you didn't like the statutory construction argument, even if you said, ugh, it doesn't say indirectly either, the result would be manifestly absurd. And let me explain my viewpoint on that. In this case, you have a situation where you have a flight attendant responsible for the carriage of passengers, including children. We heard this morning someone argue about the most vulnerable of victims, which is why we have this statute. See something, say something. They're in the air. What state are we over? Should we take a look for the local authority in Fairfax or Loudoun? Should we look to Maryland? Should we look to Virginia? That's absurd. She sees something. According to the appellant, she sees her crying. She sees dad comforting her. She also sees, by the way, according to the pleadings, dad is on this side and mom is on this side. She sees enough that she says, something's weird here, and she tells her captain. According to the appellant, she then escalated her concerns. I think this is sexual abuse, captain, and the intent of this statute is to encourage her to tell someone. Was she supposed to Google the local department? That's absurd. That is not the intent of the statute. Instead, we need to get word to the ground, we get police, and they're an intermediary. They're a mandatory reporter. Why are there mandatory reporters? Because they understand who to call. They know the numbers, the 800 number of the Capitol Department or the local agency, and then that multidisciplinary approach will work itself out. Then, ultimately, yes, the department is going to be responsible for conclusions, bringing it to the court, continuing to work with law enforcement. But why enact the statute? It's to protect the children, and necessarily that means report. See something, say something. The student should be doing it, the teacher should be doing it, and the teacher, okay, teacher's a mandatory reporter, but forgive me, imagine a new teacher who doesn't know all the rules, and that teacher calls 911? We're not going to afford that teacher a protection under this statute? That's manifestly absurd. So I think that's the easiest answer, Judge Niemeyer, to your question.
Your policy is sound, and the intent is probably there. The question is whether the statute says what appears to be the contrary to what the intent. The statute does say, does include the immunity on a report to DSS. It would have been much nicer if they said report, comma, directly or indirectly to a chain of communications that ends up with DSS or something like that. But they just said report to. So the question is, did the legislature intend to limit immunity to just someone who does report to DSS and leave everybody else behind? I think it would be a majority of the reports, because I think very few people know that that's where I go. The first thing they think when they see serious child sexual abuse is the law.
Right.
And of course, legislature clearly locked the law into DSS. They work with each other closely, and and are intended to help out on this. But I think Judge Keenan knows well, and we have seen well, that the Virginia Supreme Court likes to read its statutes the way they say, and maybe they would not read directly or indirectly in there. I'm not sure that's adding substance or not.
Forgive me.
Yeah.
Let me read additional portions of the statutory scheme. We've talked about 1512, we talked about 1510, but in addition, local department is defined by, guess what? The local department. So you have the capital D, or report it to the local department, which the statute says is the local department of social services. When you read social services becomes then more broad. Foster care, adoption, adoption assistance, child protective services, domestic violence services, or any other program implemented in accordance with the regulations. 1503 then goes on to say that the local department shall notify the local law enforcement agency of sexual abuse suspicions. So this is really escalating. This is not just neglect, maybe the child
So
didn't
the
get.
legislature understood the distinction between the DSS and law enforcement. They understood they were two different entities. So the only way that you can prevail today is to convince us that legislative purpose trumps plain meaning. Isn't that correct?
No, Your Honor, and I would have two responses to that. It does not say directly to law enforcement. So to the local department. So for example, under Wolf, this very court encountered a situation where, in fact, there was a report to police. And ironically, it was because the DSS voice message said, contact the police. Because guess what? The local department isn't available 24 hours a day. You can't always reach them. Does that mean we should ignore our suspicion of child abuse? No, of course not. And then the other part, Your Honor, in response to that is the Virginia law still allows for the ignorance of statutory construction if the result is manifestly absurd. That's Halifax.
I would think your case is helped best if we use a verb that is a communication verb, that we conclude that word includes direct or indirect. The question is, when you call somebody on the telephone and you go through an operator, is that direct or indirect? Yet we say we call somebody. If we report something to DSS, we report it to our teacher who reports to DSS, that still might be reporting to DSS.
But the report wasn't made to DSS in this case.
Your
They
Honor-
were let go immediately. So it seems to me your whole analogy fails from the get-go, because the direct versus indirect analogy would be inapplicable when no report was made indirectly to DSS.
I disagree for two reasons. One, the evidence is not in the record one way or the other. If
Okay, but
that
there is
reporting
no
was
evidence
ever
of
made.
you do agree there's no evidence that DSS was contacted in this case by Delta Airlines?
I agree, but
Okay.
it was reported to a mandatory reporter, and why is that important to me? The mandatory reporter's failure to report the suspicion is a violation, and they can be prosecuted. That's why it's mandatory
So
reporting.
you're saying you're assuming that it was done?
You
I'm not
presume
making-
it because they're mandatory. In other words, had they concluded that there was sexual abuse, they would have reported it. That's not a hard gap to jump on under the statute. I think the harder gap is whether going through the captain, and it seems to me if you report to the police and they decide there's nothing to it and they don't report to DSS, if there was something to it, it would be pretty clear they would report to DSS because they have to, they're taught that, and it's mandatory and they're punished. But the bigger question, I think, is how broadly do we read the verb?
Forgive me, Your Honor, I have to step back, and I know we're dealing with the police, law enforcement, and the analysis in your view seems to be a bit different. It's still mandatory reporting. This is not an obligation to investigate. It is a mandatory report to the local department or DSS. So just because the police decided to let this person go or there lacked probable cause, there is a report of suspicion of child sexual abuse, they're a mandatory reporter. And again, there's a distinction for a reason. The mandatory reporters understand. I know the 800 number because I work in Newport News, and I know, we work closely. I know who to call. I know Jane or Bob or Mr. Smith over there. I know who to call. And that's why there's this distinction. And I understand what Your Honor is saying, but I would still say that if you strictly construe the statute, the report ultimately is the report of sexual abuse. I'm not alone in this analysis. The Wolf Court certainly agreed with that analysis, as did, and I'm going to pronounce the name wrong, there was a court in Western Virginia who said the same thing. It's a distinction without a difference. That was the language that they used. And if Your Honor wants me to get that case, I can
Is
do
it
that,
in your brief
excuse
or
me.
not?
Just for the record. So there were three courts, including this court, that agreed with me that there is a distinction without a difference. It is the Blott versus Edwards case, Northern District of Western Virginia in 2009, that drew the same conclusion. That the report to law enforcement was a distinction without the difference for the purpose of finding immunity, and they found immunity in that case. And I believe that that's particularly persuasive and compelling. But coming back to the Wolf case, the Wolf case analyzed.
Is that case in your brief?
It is in our brief, Your Honor, yes. Do you mean the Blott case? Yes, Your Honor, it is. And in the Wolf case, back to 2009, Judge Wilkinson, who also was joined by Judge Gregory, who I know is also still on this court, found the same. In that case, there was a telephone call to DSS, but they got a voice recording that said, call the police if you have a suspicion. And that's what happened. And so under the strict reading of the statute, Your Honor, Judge Niemeyer, if my colleague here is correct, they don't get the protection because ultimately the report was made to law enforcement. They involved
Right,
law
but
enforcement.
Wolf, they were talking about bad faith and malicious intent, weren't
Yeah.
they?
That was the second part of the analysis, yes,
Yeah,
Your Honor,
yeah,
but
I mean, that's where the case went. You know, and I guess this really all comes down to the question of legislative intent and what role it plays in statutory interpretation in Virginia law. I mean, isn't that basically the issue here?
I agree it's the issue, Your Honor, but the way I read that statute is that there is no requirement for direct, that reporting to an intermediary, just as in Wolf, is sufficient to afford the reporter protection. The reason being, I'm gonna have to end the way I started, protect the children. And the chilling effect that
Everybody
it
wants
would,
to protect the children.
Yeah.
You're making a jury argument here
Yeah.
that is perhaps ill-placed. Everybody wants to protect the children.
so one of the other portions of Wolf, Your Honor, before it got into the bad faith analysis, there is language that talks about reporters are protected. A person who reports suspected child abuse pursuant to either 1509 or 15.
Yeah, could you give us the page site?
Yes, Your Honor. .317. It's really 317 to 318, Your Honor. But that the reporter shall be immune from any civil or criminal liability in connection therewith.
Which case is this?
This is Wolf, Your
Wolf,
Honor.
okay.
So this is Judge Wilkinson. The statutory framework is designed to encourage those who genuinely suspect a child is at risk to report their suspicion to authorities without fear of civil liability. And again, this is a case where the initial report actually went to a local sheriff's office, who then, of course, worked in tandem with the local Department of Social Services.
Right, but the issue, again, the holding of the case was on the bad faith. You know, they say here, plaintiffs have not alleged or suggested any untoward animus, pre-existing bad blood, desire for revenge, or the like that would strip Stevens of immunity. And then goes on. That's the holding of the case.
That's correct, but in order to get there,
It's stating some very garden principles that the purpose of the statute is to protect children. But it's not saying what you're saying regarding the chain of reporting.
But it does presume immunity in those factual circumstances.
Correct, Your Honor, correct.
It grounds it on, it assumes there is immunity with it.
That's correct, Your Honor, and the.
Let me ask you this, because
Yes, Your
I
Honor.
see your time is almost up. Because I think we've gone, the question regarding immunity, but if this court was to find that the immunity applied to Thomas, the reporter, does that immunity, is it derivative, I guess, in terms of Delta and Endeavor?
Absolutely, Your Honor. This is not an issue of procedure. This is an issue of immunity, and she was working for her employer at the time, and the same question would be asked. If I was standing here on behalf of Ms. Thomas or either airline, the question remains the same. It is about her behavior and whether her behavior warrants the immunity under the statute. So
And the only reason I ask that is because I'm familiar with the case, I'm sure you are, that Stute case, where it says that that the liability does not extend to the employer, and I know the facts in there were different, and the statute was a little bit different. That's I think it's the immunity when you report, if you report, if you try to help someone and then you injure them or whatever, it is a negligence case. But that case does give me a little bit of concern about whether or not it, if it applies to, and I know that's one of the issues that they have here, but of course, we've been talking about Thomas, but if we are to decide that Thomas has immunity, does that mean that Delta, and based on that case, does that mean that Delta and Endeavor have immunity?
yes, Your Honor, necessarily so. And if it were the opposite, it would be because they cannot be held responsible for her reporting. They shouldn't be in the case at all. But if, in fact, they can be held responsible under respondeat superior, then they necessarily would be afforded the immunity that she would be afforded. Thank you very much for your time, Your Honors. I would ask that the decision be affirmed in the
Thank
lower
you.
court.
All right, Mr. Clark.
Your Honors, briefly, I think some issues are getting a little bit befuddled. Delta is not a mandatory reporter in this case. This was passed on from a flight attendant to the pilot, a Delta pilot, to the station manager, who was a Delta employee, to the police. Nobody in that chain was a mandatory reporter. And that's very different because that meant that there was a police response instead of a DSS inquiry into validity. So let me go through that really quickly because I think we're befuddling issues. Under 63.2-1508, a valid report or complaint means the local department, that's DSS, has evaluated the information, allegations of the report or complaint, and determined that the local department shall conduct an investigation, family assessment, or human trafficking assessment because the following elements are present. And then there's a bunch of elements. So first of all, they are trained, they have CLE hours, they have education requirements for these workers. They make the initial determination of whether it is in fact a valid or invalid complaint. Not call the police yet. They make the threshold determination. That is in subsection I of 1503, the statute she just cited. They don't all get reported to police. You have to read that the valid complaints get
But
reported.
this is nothing new. What you have is you have various people getting information and making assessments.
Correct.
And it's clear that Department of Social Services is given the tools and and they have the expertise to address this issue, and that's where the legislature wanted it handled. But they also recognize that this also implicates the criminal statutes, and they have a close relationship with law enforcement. 1507 is all devoted just to that, creating that relationship. And then they have this immunity, which is a little strange. The language is not quite as direct as I thought it might be. The language says a person making a report pursuant to 1509, a complaint pursuant to 1510, or takes a child into custody pursuant to 1517. So a person making a report pursuant to 1510, that would be this one.
Yes, sure.
The question is a person making a report pursuant to 1510, do they have to be making it to DSS?
Yes, Your
Or
Honor.
do they have to make it with the intent to, because 1510 is a person who suspects child abuse. That's the nature of the complaint.
They don't have to be right, Your Honor, they just suspect it, and if they make it pursuant to 1510, but I would add, going beyond, look, if you would, look at 1510 and look at all the permutations that it gives you. So it starts out with, give a complaint to the DSS, you are immune. Then it says, well, what if the person who the complaint is against is in the local DSS? In other words, you now have a wolf guarding the sheep situation. You can't make the complaint to the local DSS. Well, if they're interchangeable, surely, Your Honor, the legislature meant that now the judge can call the police. No, it says, if an employee of the local department is suspected of abusing or neglecting a child, the complaint shall be made to the court of the county or city where the abuse or neglect was discovered.
I know,
Still
but
not the
none of
police.
this talks about the immunity. The immunity section uses just the word pursuant to.
Pursuant to, Your Honor.
So
In other words,
somebody makes a complaint pursuant to 1510 and does so imperfectly, it would seem that 1512 would still say it's okay. A person making a report pursuant to, making a complaint pursuant to 1510 is immune. Does that include it has to go to DSS, or does that mean referring to complaint just pursuant to as a complaint about sexual abuse? Anyway, it's the statutory construction is not totally black and white in my judgment.
Your Honor, I would say that I think this is being presented as a fallacious argument to a certain extent. The competing concerns are already baked into the language of 1510 under a non-mandatory report. So in other words, this was a non-mandatory report. This isn't a 1509, this is a 1510. I could easily just say, you know, we all want to protect the children, that's clear. I could easily say that a spurious report that has, if you give too much immunity, we have something like this. There was no indication that this is human trafficking. There's no indication this is sexual abuse. How many sexual
That's not an issue here. You know, you keep wanting to go off on these things. The question is immunity. That's the only issue that we're really addressing here.
Correct, Your Honor.
And we're looking at, we have to assume there was a suspicion. There's no evidence that of this flight attendant didn't know these people in advance. They has no motive, and you've alleged that in the complaint. Basically, there's no malice, none of that exception. We're looking at whether this immunity, and that's where your brief couches it, is granted where the report is not made to DSS.
You're correct, Your Honor, and it's not. Under the
I
reading of the
understand your
statute,
argument,
and if you go through all those permutations under 1510, it's remarkable to think that the legislature never considered that calling law enforcement was an available option, even though they use law enforcement in 1507. They clearly want these reports to go to DSS, Your Honor.
Well, it told you where to make the reports. When you have a complaint, it tells you where to make it. But the immunity isn't conditioned on that. The immunity says anybody making a complaint pursuant to 1510
Right.
is immune.
Yeah, Your Honor, and I think the legislature clearly meant pursuant to it means
Well, let me
in
ask you
accordance with.
this.
Yes, ma'am.
I asked her the same question because I know this is your other argument in the case is that if we were to find that Thomas was immune, I think it's your position that that immunity does not, I guess, transfer is not derivative to Delta or Endeavor.
That
And
is
so what's
correct,
your, what's your best argument?
I have a brief, may I grab something, a paper from right back here, Your Honor? It'll only take 10 seconds. Well, I'll just tell you, at the end of the Stutes case, Your Honor, the court quotes Hughes versus Doe, and it's very clear that it has to be a verdict of non-negligence against the immune actor. And that was even in the Stutes case, Your Honor, where they found that the ambulance drivers, the EMT personnel were in fact immune under the Good Samaritan statute, and there was some other different background issues there. But they were in fact immune, and even then the court remanded that for because the record was unclear whether.
It'd be sort of strange to have an employee of a company who makes a report immune, but the company itself on derivative liability is not immune.
It is, in fact, Virginia law, Your Honor. There is no, first of all, count one is failure to train. You know, our position on this was there was absolutely no reason for this flight attendant to say this was human trafficking. This is contextualized behavior. He's comforting his daughter who is crying in turbulence.
Well, we can't resolve that here.
I understand that, but you know,
There's
it's got
something that troubled her, and she reported it, and she added later there was some inappropriate touching. So we can't resolve that. That's alleged in the complaint, and the issue here is whether she's immune from making that report.
Yes, Your Honor, and so our count one is failure to train, failure to supervise, failure to provide proper protocols so that she could differentiate normal, innocuous, completely good behavior from human trafficking and things of that nature. And it appears my time is up,
Yeah.
Your Honor. I'd like to distinguish wolf and beloved,
Right,
but
sir. All right, thank you very much. We'll adjourn court for the day and come down and greet counsel.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.